afternoon, everyone, and thank you for joining us today. My name is Michaela Vrazdova, and I'm a senior associate at Scott Legal PC. Today, we are going to spend some time talking about the National Interest Waiver EB2 green card category. We'll go over some common questions we often get from our clients and potential clients about the NIW. A few things before we get started. So Scott Legal is a full-service immigration law firm, and we assist individuals pursuing various types of visas and green cards, including family-based green cards, employment-based green cards, and investment green cards. Our main specialty is assisting entrepreneurs and investors, and we do process a high volume of NIW cases. We will continue to have this webinar series, and we'll have at least 2 webinars a month on different immigration topics. At the end of this webinar, we'll send you out a few things. We'll send you our NIW visa guide, which is a comprehensive visa guide discussing the NIW green card. We will send you a PowerPoint presentation about the NIW, and we will also send you a link where you can sign up for additional future webinars, and also a link where this webinar will be recorded. And this webinar will be also available on our YouTube channel, and we do encourage you to subscribe and hit the notification button on YouTube, on our YouTube channel, as we do regularly post immigration videos there. And we'll also send you a link where you can sign up for a consultation, and you can discuss your particular situation with one of our attorneys. So today we are lucky to have Jie Huang, who is a senior associate at Scott Legal, and she has a vast experience with processing NIW cases. And finally, for any question you have, you can add the question to the chat box or to the Q&A box, and we'll get to all questions as we talk or at the end of the webinar. So why don't we get started with the NIW? So GA, could you tell us what are the eligibility criteria for an NIW?
Sure. Thank you, Michaela, for the introduction. So yeah, before discussing the specific eligibility criteria, maybe I'll just go ahead and give everybody an overview of what is an NIW and what are the reasons why someone might apply for an NIW. So the NIW, as we say, is short for National Interest Waiver. And it is a subset of the EB2 employment-based green card, employment-based immigrant petition, right? So immigrant petition means this is an application for a green card, and this means permanent resident status in the United States. Now, a green card gives someone the ability to live permanently in the United States and work for any employer or not at all. So, and having a green card also opens up the pathway to U.S. citizenship. So there are a lot of reasons why someone may want this. So NIW is a popular choice among individuals who want to apply for a green card on their own. And this is called self-petitioning. So this means you can apply as an individual for a green card, whereas normally you need a U.S. sponsor. EB1A, for extraordinary ability individuals, is another category that allows self-petitioning. Now, because you're allowed to self-petition, this means an applicant does not need a U.S.-based job offer, and you do not have to have a U.S. employer who is willing to sponsor you. And each applicant can also avoid a time-consuming process called the labor certification process, which usually comes with the employer-sponsored green card process, which means each U.S. employer must be willing and able to test the U.S. labor market to see if there is anyone else in the U.S. who is available to take the job. But the NIW, if you qualify, you don't have to go through that process, which can streamline the pathway to the green card. And now that premium processing is available for the NIW has become a very fast way an individual can apply for a green card. So for the I-140 portion, which is the underlying petition for eligibility for the green card, you can get an answer from the government within 45 days. But it is worth noting that the priority dates have retrogressed for green cards in this category. So there could be many more months of waiting before you are actually allowed to file the petition for the green card, even once your I-140 is approved. But, generally speaking, especially compared to the EB-1A category, which is only accessible to a very small percentage of people in each field who have risen to the very top of their fields, the NIW is popular because it is accessible to more applicants who are relatively at the beginning of their careers, as long as they can show that their work will create significant benefits and contributions to the industry or society. So yeah, now I will talk a little bit about the eligibility criteria for the NIW. So first, there is a threshold requirement that each applicant should meet to qualify for the EB2 category itself. And you can do this by two ways. First, you can show that you have an advanced degree, which is defined as a master's degree or above. So a PhD would qualify. Also, degrees like a JD, Juris Doctor, or an MD, Medical Doctor, or an MBA also qualifies as an advanced degree because you need a bachelor's degree in order to gain admission to those kinds of programs. It does not need to be a US-based degree, but you do need to obtain a foreign education equivalency report, which confirms that your degree is equivalent to the same level degree in a United States institution. Now, let's say you don't have a master's degree or above. And also, I forgot to mention, another way you can meet the advanced degree threshold is if you have a bachelor's degree in your field and over 5 years of progressive work experience in your field after you receive your bachelor's. So this can be considered an equivalent to a master's degree if you have 5 or more years of progressive work experience. And progressive here means that your duties have been changing over time. So if you graduated from your bachelor's and you took one position and that position has not changed and it stayed the same, your title is the same, your salary is the same, then it unfortunately will not count as progressive work experience. In order to meet the advanced degree threshold, you do need to show that your duties have become more senior over time and your title has changed, for example, from associate lawyer to senior lawyer, for example, or if an engineer, you can be a junior engineer, but then you become a senior engineer in several years, and your salary has also changed progressively over the years. Those are some of the evidences you want to prepare if you are meeting the threshold requirement through progressive work experience. Now, let's say you do not have a bachelor's, you do not have a master's, then are you out of luck? Well, the answer is no. If you can show that you have exceptional ability in your field, that is another way you can meet the EB2 threshold. Now, there are a variety of factors that go in there. Generally, you need to show that you are operating at a level that is significantly above what is ordinarily encountered in the field. And there are evidentiary criteria you must meet. You need to show at least 3 out of 7 enumerated evidences. And this includes, for example, 10 years of experience in your field, membership in professional associations in your field, whether you have a related degree or license, have you received any recognition in the field, such as awards won, and or if you have a high salary compared to other people who are working in your field. So let's say now you meet the EB2 threshold, and unfortunately, that is only the first step of the NIW eligibility criteria. There is also the main part of proving that you qualify for the NIW, and to do this, you need to show evidence under 3 prongs of what is called a matter of Danazar test, and I'll go over what these 3 prongs are. So the first criteria is that your work that you're proposing to do in the United States must have substantial merit and national importance. Now, substantial merit can be shown in a wide variety of fields, including arts, including business, including culture even. But in order to show national importance, you do need to show that your work will have broad implications to a field. And the language that the government uses is national or global implications within a particular field, such as if you are developing a new medical approach that will advance the field as a whole or advance how how that particular disease is being treated, that can count as a national or globally important advancement to the field. Similarly, if you're developing and disseminating an improved manufacturing process that not only benefits your processes, but also can be used by other industry actors that can improve how things are done in the field as a whole, those are the kinds of broadly important endeavors that the government is looking for when they're assessing your case and seeing whether it meets the national importance standard. Now, the second part of this inquiry is whether you yourself as an individual are well positioned to advance the endeavor. And this is because you could have great ideas with a project that is likely to affect the field as a whole, but if you don't have relevant experience that can show that you are best suited to advance this project, then the application is not going to work. So for well-positioned, the focus is really on the individual themselves, right? So you would show that you have a relevant degree, relevant education. You would also show that you have relevant experience. And really what the government is looking for is, do you have a record of success in similar and related endeavors that is directly related to what you're proposing to do in the United States? And how has those prior projects have been received by the industry as a whole? Has they generated positive feedback? Has they generated positive industry discourse in your field? Those are important considerations you want to look at in discussing whether you meet the well-positioned prong. Now, the third category for the eligibility criteria for the NIW is, on balance, would it be beneficial to the United States to waive the labor certification requirement for you? And to the extent that you meet prong 1 and prong 2 of the NIW criteria, it is a relatively straightforward process to meet prong 3 because you can really show that the interest that can be served on letting you, advance this endeavor, which will broadly impact the field and result in systemic benefits, is a lot higher benefit than not letting you come in and do this work and saving one U.S. job for one other U.S. employee that could take your place. So, and especially for entrepreneurs, there is an additional argument we can use by saying that an entrepreneur doing a business endeavor is likely to create more U.S. jobs by running their business, as opposed to the benefit of saving one U.S. job by imposing the labor certification requirement and not letting you come in and develop your business. So there are a variety of arguments you can make, provided that you meet prong 1 and prong 2 of the matter of Danisar factors.
Thank you, GA. And could you go over a bit more about the exceptional ability standard and kind of explain, like, is it the same or kind of like similar standard as the extraordinary ability for the EB-1A green card, or is it lower? And just kind of compare those two standards.
Yeah, definitely. So exceptional ability is not the same as proving extraordinary ability in the EB-1A context. And this is also a question that we get a lot, right? And another thing I wanted to emphasize here is you only need to prove exceptional ability if you cannot prove that you have an advanced degree. So people who already have a master's degree or a bachelor's degree in 5 years of progressive work experience, they do not even need to provide any evidence relating to exceptional ability. And because this is an alternative way to meet the threshold requirement for the EB-2, right? And so the operative language is that you need to show a degree of expertise for exceptional ability that is significantly above that ordinarily encountered in the sciences, arts, or business. And the evidence that is required is very different from an EB-1A. For example, and this is just an example, but to meet the extraordinary ability threshold in the EB1A, you need to show that you are a member of an organization that requires extraordinary achievement of their members. So you cannot just show that you're a member of, let's say, the New York Bar Association, for example. If I'm applying for an NIW, and if I want to qualify under exceptional ability, I just need to show that I am a member of a professional organization. So it's very different, right? Because if the New York Bar Association requires of its members just to have a license and be active in the profession, then I can meet that category. But if I were to apply under the EB1A category, and if I were to prove that I'm a member of an association that requires outstanding achievement of their members, I likely cannot meet that threshold, because membership of the New York Bar Association does not require a lawyer to be extraordinary in the field in order to be a member of the association. So in each of those criterias, the relevant language is very different, and I can definitely say that it is a lot lower standard to meet than the EB1A.
Thank you. And could you give us an example of a national interest waiver applicant who met each of the NIW criteria?
Sure. So let me discuss a case study from a case that was eventually approved at the AAO, which is the appeals court. And it is interesting because it discusses a case of an entrepreneur. And this entrepreneur in particular proposed to set up a small consulting firm. And it is interesting that the case actually discusses that it was not a big consulting firm, but it is a small consulting firm. But what the applicant proposed to do was important enough to meet those criteria for national importance and also well positioned. So let's discuss how this person met the three-pronged test. So to start with, the substantial merit and national importance, what this entrepreneur proposed to do was to set up a small consulting firm focused on leading projects, coordinating projects with relevant organizations in veterans welfare field. So the purpose of this work was to improve veteran services and create new programming that can really help wounded veterans return to productive society by giving them opportunities to access job opportunities and personal development and things like that. So he submitted a business plan in which he discussed his plans to coordinate those projects, to facilitate this reintegration. And importantly, this business plan included letters from prospective clients and also really had an explanation of how his projects will improve the offerings that are already available in the U.S. that were being given to these veterans. And these partners who wrote those letters of support included leading philanthropic organizations in the United States, leading government entities, and major businesses that were willing to partner with him to make this plan a reality. So not only was this plan very well developed, but also this plan was there was some traction from industry and government actors for this plan, which really helped persuade the government that this plan was ready to go and ready to hit the ground. And in further support of the importance of this work, the individual submitted government reports, news articles, letters from senior officers in various military government organizations and philanthropic organizations, really explaining why these projects were needed and explaining the gaps of veteran care that were noted in the field and why this work was really needed to improve the quality of services given to veterans. So based on those evidences, the government found that the person's proposed endeavor indeed had substantial merit and national importance. Now then, how did the government find that this individual in particular was well positioned to advance the proposed endeavor? So this person had many years of experience already working in veterans care and philanthropy, right? So this person had a very remarkable success record. in his past endeavors. And how he talked about these endeavors was really through expert advisory opinions from people who had worked with him or people who had worked in partnership with him, talking about some of the past projects that he had actually organized and what the impact of these projects were in the field. So, for example, one letter described how this person had these high-level connections in the US and UK charitable sectors, where he was able to tie in millions of dollars in charitable support from philanthropy organizations to actual veteran service organizations, such that the veteran service organizations were able to develop new campaigns based on this new funding support, right? And there were concrete examples in these letters where the impact of each of these projects were described in detail. So in one example, a senior official in one of these organizations that he partnered with talked about how actually hundreds of veterans who had graduated from the program that he helped organize were actually able to find jobs, and they were employed again and also reintegrated to productive society as a result of these programs. So those kinds of case studies really helped to prove that this individual in particular had the expertise, and because of this expertise was well positioned to do a similar endeavor in the United States specific to his business plan.
Thank you, Gia. Now let's discuss kind of the NIW for like how can entrepreneurs use the NIW green card. So
Sure thing.
When an entrepreneur is like wants to apply for an NIW, does the entrepreneur like need an already established company that has been operating for many years, or can it be a startup?
Yeah, so that is a very good question. And the answer is you don't need to already have an established company in order to apply for the NIW. You can instead propose that you will set up a new company once the NIW is approved. So in contrast to the E2 visa, in which you already need to have an entity and you already need to have spent a lot of expenditures to set up the company to have it ready to go, there is no strict real and operating requirement like that. However, the proposed plans must be very specific and credible, right? And so one critique that we see from AAO cases that get denied is that if the individual is just proposing that, oh, okay, I will come in and look for job opportunities in the United States in my field, like that is likely not going to work. That is not specific enough to really show that the project will have national importance and substantial merit. And in a lot of these opinions, the government reiterates the idea is that the NIW cannot be used to just help somebody do a job search in the United States. Instead, what you really want to do is prepare a very specific and credible business plan, and also support this with third-party evidence that shows that there is traction in your industry for this plan. So, for example, letters of interest from relevant partner entities, potential partners and clients, that can give more credibility to your plans. And also, if you are operating in an industry where it is highly technologically driven, you could try and get grants or incubator admissions from U.S. entities that can really show that the relevant industry actors are interested in your business plan. So even if your business is not fully developed yet, there are programs you can partner with where you can develop these plans further. And all of these actions that you do in the industry that show industry traction can really help strengthen an NIW petition.
And what would you say are the pros and cons to applying, with established company versus a startup?
Yeah, sure thing. So let's discuss the pros and cons of having an established company first. So if you have an established company in the United States, let's say you are on an E2 visa and you already have set up the company and you have been growing the company for several years. The pros for this is that if you have experienced significant growth and you have hired a number of employees, and if you have generated revenues and tax revenues in the process, all of those documentation can be a very good objective evidence to support your projections of future job creation and future revenue generation and future growth. So provided that you have that growth trajectory already, it can strengthen your case and make it sound a lot more credible and less speculative because you already have that track record of growth. Another advantage of using an established company to support your NIW petition is that, let's say you have developed an innovative approach or innovative product, and that has been sought out by major players in the industry. Let's say you developed architectural products, and a Google office in your city has signed up to implement your product in their office because it's so superior than other solutions. All of those contracts and projects that you've already done in the United States, especially if they're done with high-profile entities, or especially if they were with government entities, you can use them as evidence that there is significant industry interest in your field, and also support how you're well positioned to continue your work at the cutting edge of your field. So having an established company and business really helps you build that record of success. Now, let's talk about the disadvantages, though. So if you have an existing company, and so there are two ways to approach this. So if you have an existing company, but it's not related to your proposed endeavor, let's say you operate a cleaning company instead, but then you are proposing that you will be entering the tech space, that link may not be a very persuasive one. So that is one thing that your track record may unduly restrict you from the types of proposed endeavors you can think about. The second thing is your business record if you have an existing company, and if it's not doing so well. So if you have been operating your company for 5 years, let's say, but if you are the only proprietor, or if you have 1 or 2 employees, then it may be difficult to go from that record to a projection of explosive growth to the degree of where you can support substantial positive economic impact, for example, is that if that's part of your argument, or to support substantial job creation to the extent that would support an NIW petition to rise to the degree of national importance. So that's one disadvantage of applying when you have an established company. Did I all discuss the startup option yet? No,
not yet.
Okay, so now then I'll move on and discuss the startup option. So what are the pros and cons of applying for the NIW based on a new startup? So the pro is that as long as the business plan makes sense and is credible, there is really no need to show a history of high performance in terms of business or growth rates. You can simply show the work that you have been doing to prepare for this new business project, and really go with the persuasive business plan and interest from the industry on your business plan to support those projections. However, the disadvantage of going with the brand new startup is that if you do not have a record of prior related work in your field, or if you do not have a record or evidence of significant current industry traction in the project, for example, incubator admission or venture capital investment, the proposal can sound speculative, and that is a risk. And if it really seems like there is no other third-party evidence that can really back up to why this project can work, this may not be enough to secure an NIW approval.
And Gia, you mentioned before the E2 visa. So do you see in practice a lot like people are moving from the E2 visa to the NIW? How common is that?
Yes, I would say it is a very popular choice for an entrepreneur on an E2 visa to move to an NIW, and there are various reasons for this. And one of the reasons is that for an entrepreneur, it is difficult to get a company to sponsor the entrepreneur for a green card. And this is because the entrepreneur has majority ownership in an E2 business, right? However, the NIW does not have restrictions like that. So the NIW is a popular approach when an E2 entrepreneur is looking to move to a green card. And some of the advantages that that could be relevant is the ones that I've mentioned with regards to applying with an established company. If you already have impressive growth rates, and a track record of hiring employees that can support future projections of growth. And another way I've really seen this work well for a lot of our E2 clients is if they have ongoing projects with very attractive industry front runners. For example, let's say you are operating in the aerospace industry and you are working on a project where you're helping testing and certifying new hybrid electric airplanes that have never been introduced to the market before, but if introduced to the market, it could really revolutionize the industry. Those kinds of high profile projects are very attractive case studies to really bring in and fold into your proposed endeavor. And having an E2 company that you're already operating can really give you a lot of opportunities to explore these projects that can be very attractive for the NIW.
Thank you, GA. So let's now move and discuss the timing and other considerations when moving from a non-immigrant visa, such as, for example, E2, as we mentioned, to the NIW. So what's the estimated timeline to get, the actual green card from the time you file the NIW application?
Yeah, so it is worth mentioning that there are multiple stages to getting an employment-based green card. So the first step is the I-140 application, which is the underlying NIW application. And so for this one, there is an option to use premium processing, which can get you a decision or an RFE within 45 calendar days. So if you do get an RFE, which is a request for evidence, you would spend some time to gather the evidence that they're asking for and submit a response. And once the USCIS receives your response, they will take another 45 calendar days after they receive the response to get you a decision. In practice, we have seen approvals without an RFE very quickly if we use premium processing. Interestingly, anecdotally, we've had one case be approved as quick as 7 days after USCIS received the petition. So it really can depend on what officer and what office it gets to. But anecdotally, we've been seeing very quick approvals. And without premium processing, it can take about a year just to get the results on the I-140. And that is only the first step. So the second step, once you have the I-140 approval, is you can either file for an I-485, which is the, if you're already in the United States on a different status, such as the E2, you can file the I-485 to adjust status to a green card holder. And what this does is it allows you to continue staying and living in the United States while your green card application, the permanent residency application, is processing. And at best, this second stage for the I-485 can take many months. At worst, it can take multiple years. So one thing to note is that once you file the I-485, you can also file for an employment authorization card and also apply for a travel authorization card. And once you get those things, which typically come down faster than the actual green card, you can use that employment authorization card to work for anyone you want. And you can also use the travel authorization to travel in and out of the United States while your green card application is pending. Now, the other option to apply for a green card, and this really applies to people who either are not living in the United States, rather they are currently living abroad, and they apply for the I-140, they will need to go through what is called consular processing, which means once you have the I-140 approval, you would apply through your home country's consulate or anywhere you are a permanent resident of to apply for an immigrant visa, and you would work with the consulate to get them the civil documents and other procedures that are necessary, and eventually schedule an interview. And you would go to the interview and talk to the consular officer, and once once you pass the interview, they will give you the immigrant visa stamp. And with the immigrant visa stamp, you can then enter the United States as a permanent resident. And if you are in the United States, you can still choose to proceed with the consular processing. And consular processing can make sense if really you need to travel back and forth a lot, and you can't afford to have that gap where you cannot travel right after you file the I-485, right? So if you choose for consular processing, that just means, you know, at the time of the interview, you would need to go to the consulate abroad where you're processing your case, and then do the interview, get the visa stamp, and then come back to the United States. With regards to timing, similar to the I-485, you know, with the aftermath of COVID-19, many consulates are different on how backlogged they are, right? So consular processing can also take many months, sometimes over a year, depending on the workload of the particular consulate. So all in all, if you think about the general timeline, you can expect to be spending, at least a year in total, and sometimes many years from the point of applying for the I-140 to the point where you actually have the green card in hand. It could be quite a long journey, which is the reason why you should definitely consider working with a law firm that can guide you throughout the entire process.
Thank you, GA. And does filing the I-140 kind of give you any status in the US? So like, let's say that someone's E2 status is expiring, you know, and then they file the I-140, like, does that allow them to stay in the US?
So this is a common misunderstanding that we have, and the answer is no. Just filing the I-140, which is the first part of the application, does not give any status for the applicant to continue staying in the United States. So if your E2 is expiring and you just filed your I-140, once your status expires, you do need to leave, unless if you also file the I-485. Now, the caveat here, though, is that the priority dates must be current in order for you to be able to file the I-485, either concurrently or after the USCIS receives your I-140, right? And currently, right now, for the EB2 NIW category, unfortunately, there is a retrogression in the priority dates. This means you can apply for the I-140 today, but there is likely a long waiting period, many months, before you are allowed to file the I-485 based on that pending I-140. So the short answer is no, just filing the I-140 does not give you any status. You are able to stay in the United States after you file the I-485 portion, but you cannot always file that concurrently with your I-140.
And what about family members of the main applicant? What family members can apply for a green card with the main applicant?
Yeah, so your spouse and your dependent children under 21 years and unmarried can join your green card petition as dependent beneficiaries. And that is also another very popular reason why we see a lot of applicants move from, let's say, an E2 visa to a green card, is that you really want to secure that green card for your family before they age out and become older than 21 years.
Thank you, GA. Now let's move and discuss what's usually included in an NIW submission. So from your experience, GA, how long does it usually take to kind of put together all the evidence for the NIW petition?
Yeah, so that is a great question. And it really depends on how quickly the client can collect all of the relevant evidences that they have. I would say on average it's taking around 90 days if the client really focuses on it. And the reason why I give 90 days is because I'm also counting the time it takes to help the client finalize the expert letter drafts and their statement of proposed endeavor drafts, which can take a bit of back and forth with the lawyer, as we do give some feedback and suggestions on how to improve those contents. And so what the client will do in that period is really prepare all the documents that will support and present the proposed endeavor. So as I mentioned, the statement of proposed endeavor is sort of an elevator speech talking about what you're intending to do in the United States. For entrepreneurs, you do also want to prepare a business plan talking about your hiring projections, your projects, and what kinds of revenue generation we can expect from your business endeavor. Expert letters from a variety of senior actors in your industry, or even if you can get a letter from a government agency, that is also very helpful. So you would also work with the experts to finalize what the letters are going to say. And there are some specific contents that the government is looking for in those letters, such as concrete examples about what you have been doing in the past and what the impact of those things were, and also a discussion about your current proposed endeavor, and what are the expected benefits of that proposed endeavor, and how will your proposed endeavor result in broad systemic benefits to your field. So all of these contents are developed through the letters. So it can take some time to make sure that the required content is there. And simultaneously, the applicant will also collect records throughout the applicant's career that describe the impact of their past work. So, for example, if you have published any articles in your field, relevant articles, we would want copies of those articles. If you have made any presentations in industry conferences, we can also include proof of that as proof that your work has previously had traction in your field of endeavor. And if there has been any media features and articles about you and your work, or your current project that you are developing in the United States, we would get copies of those media articles. If you have gained admission to any prestigious incubators or accelerators programs, or if you've received any grants from government agencies or VC capital investment, all of those things, we would get the third-party evidences such as the agreements for investment, invitation letters for these incubators. All of these things we would collect and include in your petition to support your case. So evidence collection can definitely take some time as well.
And GA, let's say that someone is here on an O1 visa and has a lot of old recommendation letters that were submitted in the O1 visa application. Can those be reused for the NIW?
Yeah, so probably not exactly like they were submitted before, right? And so there should be some edits made and some changes made to those letters, because the focus of the O1 visa, for example, and the NIW is different. For example, if, for a prior O1 visa, the focus is on the individual and why the individual's own abilities are considered extraordinary. However, the focus of an NIW petition is, in many cases, is on your prospective endeavor as well, right? So why does your proposed endeavor have national importance? And for that, it is really future looking, as opposed to looking at an O1 letter, which is past looking at what you have done in the past and why that makes you extraordinary. So there could be some content that we need to be added to those letters, and also maybe some contents that need to be phrased differently. So the operative language in the O1 would be extraordinary ability, but we would probably want to change that language and instead talk a lot more about national importance, impact of your work, and broadly impact the field or things like that. So the favorable language in those letters are very different. So we would likely edit quite heavily those letters before having them signed again. Although you can certainly use the same experts, you would just be giving them a new letter for them to review and sign that has the relevant language and content that we're looking for.
Perfect. Thank you, GA. And now finally, let's discuss some tips for entrepreneurs who want to apply for an NIW. So, let's say that you have a consultation with a client and entrepreneur, and it's kind of like a borderline case. What can like entrepreneurs do in general to kind of strengthen their NIW case?
Right. So there are several suggestions I would give to clients in such cases. So the general advice I would give is really to generate a volume of evidence of how your work benefits not only your direct clients, but advances the best practices of your field as a whole. And there are several concrete ways you can support this. So one thing is, and this may or may not apply for everyone, but write academic research articles relating to your know-how and your expertise and your research projects, for example, and get them published in reputable journals. And this would really apply if you are already doing R&D in your field, right? This could be a good segue. If you're already generating research product, then you could use that data to write a research article that can be shared with the broader public. Another thing you can do that can be applicable for a broader swath of entrepreneurs is present as an invited speaker at industry conferences relating to your know-how. And we recently had an approval for a cybersecurity entrepreneur who was really active in industry conferences and gave a lot of speeches about their particular approach in cybersecurity, which was security testing. So if you have an area where you have particularly superior expertise in, if you're specialized in that field, that can really be a good way to raise your profile in the industry itself. You don't need to, publish research articles if that's not your thing. But if you give industry presentations, that can also be another way to support that your work has broader implications than just benefiting your direct clients. Another thing you can do is be active in industry associations in your field. You can take leadership positions in committees, for example, if there are projects that you are leading that have implications for the industry as a whole, not only your clients. Those kinds of public presences can really be helpful. If you're in the tech industry and if you're developing new technologies, definitely publish patents about those technologies and have evidence of those patents be included in your NIW petition, because that can also support the fact that you're developing something that's cutting edge in your field, and the government uses those data to find that your work has broader implications. Another thing you could do is, and you can also, work with a PR agency for this, but appearing in media interviews and have articles being written about you and your work is always a good idea. That can really show that your work is generating the required amount of industry attention and public attention to really support the idea that your work is more important than just helping your direct clients. Another thing that can really be helpful is if you work with government agencies as a part of your work. So if there is a opportunity to participate in government-funded research projects, or if there is a way you can apply for government grants and get government support for your work, all of those activities could be helpful in showing that government agencies are interested and invested in your work as well. So that can also be a great way to strengthen your NIW case.
Perfect. Thank you, GA. So now let's go over some questions we received during the webinar.
Sure thing.
So the first question is, how closely does the progressive experience have to be to the field of study? Is there some flexibility?
Yes, and the answer is yes, there is some flexibility. So for example, if your degree was in mechanical engineering and if your progressive experience is in aviation, that is probably related enough, right? But you can take a common sense approach, right? And if it's like, you majored in English literature and if you work as an engineer, that probably wouldn't work. But as long as both are related and both are related to your proposed endeavor, that should be fine. If USCIS is not satisfied with the progressive experience, can you lean on exceptional ability as well? And the answer to that is yes. So in that case, we would argue, and you would collect evidence on both ways to meet the EB2 threshold. You would submit evidence on both exceptional ability and the progressive experience and bachelor's degree channel. So we would argue both at the same time. And if you qualify under one, you would be able to qualify under for the NIW.
Correct. The next question is, how can I prove advanced degree with experience?
Just experience. Yeah, unfortunately, you cannot just have experience. So even if it's 12 years of experience, that alone will not count as advanced degree. So the only way you can have an advanced degree equivalent is to have the bachelor's and have the 5+ years of experience, progressive experience. And so if you don't have any of these degrees, then the only way really is to prove that you have exceptional ability.
Perfect. The next question is, if you are applying as an entrepreneur, how important is it to show past experience as an entrepreneur?
Yeah, so I would say it is quite flexible. So you don't need to have run a company in the past, but you do need to show that you have relevant experience to the project that you will be advancing. So for example, if you're setting up a company that develops software and disseminates this software, if you have relevant experience as a software engineer, that is certainly directly relevant to what you were planning to do as an entrepreneur. So you don't necessarily need to have run a company for 3 years, 5 years before setting up the business and preparing the business plan, but you do need to have relevant experience that is directly related to your project.
Perfect, thank you. I think the next question asks how the business plans work. So maybe can you just go over some, like most important sections the business plans for an NIW should have?
Yeah, definitely. So like every business plan, it should have an executive summary where you talk about what your business is planning to do and what kinds of market gaps are the business addressing and what are the economic projections and hiring projections of the business. So you would have a section on describing your products and services, where you would talk about what is the gap in the industry that you are targeting and what are you offering to the market in responses to these gaps. You would also talk about your own experience and why you are well positioned to advance this endeavor. You would also have a section on financials where you talk about the projections for revenue generation, the model for revenue generation for the next 5 years, for example. You would also talk a little bit more about who you would be hiring to help with your plan and where those jobs will be located. And if those jobs will be located in an area that is considered economically depressed, that can also be helpful for an NIW petition as well. So you would include as much detail as you can on those fronts. And you would likely also include some spreadsheets, such as the projected P&L or the projected balance sheet, projected income statement and things like that, to really show what those projections are and how you will be running your business.
Perfect. The next question asks, so how do you know the EB2 category for your country is current? Is it the date, is the important date the date you filed the I-140 or the approval of the I-140?
Yeah, so that's a great question, and it depends on the date you filed your I-140, and that is called your priority date. And once you get your receipt notice, when you file the I-140, it will say what is your priority date, and you can just read that date. And so every month you can navigate to the Department of State website, and they publish a monthly visa bulletin. So you would also look at the visa bulletin and scroll down to the table where it says employment-based categories, and you would go to where it says EB2 and look at the category there. And if the date that shows for the date of filing is and the final action dates, if it is earlier than if your priority date is earlier than the cutoff date, then you can submit your I-485. But if your priority date is later than the cutoff date that is written there for that particular month, unfortunately, you cannot file. So I recommend if anyone is in that situation to check the visa bulletin every month, because there is a movement on those dates, and you really want to make sure to submit your I-485 or green card application as soon as the date becomes current.
Perfect. And the last question is, does the age of the children freeze when you file the I-140, or can they still potentially age out, after filing the I-140?
Yeah, so there is a thing where the I-140 is processing. The age will freeze, but it'll unfreeze when it's approved and you start consular processing. So for this kind of question, I would really suggest that you schedule a consultation so that we can look at all of your facts in order to see that, because this also depends on whether the priority dates are current or not. So definitely reach out to us for a consultation.
Perfect. Thank you so much, EA, and thank you so much everyone for joining today's webinar, and have a great Friday.
Thank you, Michaela. Everyone have a
Bye.
great day.